Please be seated. Veuillez vous asseoir.
We are in open session, Mr. President.
Thank you very much. Quick housekeeping matter. I know, Mr. Kikin-Katwa, you have one as well. But before I give you the floor, we would also indicate that part of our exceptional regime to make up time, again, it's an exception. We will continue with our 1 hour lunch break today. A further matter about scheduling. We've raised a question with Council about the use of time that has now been allowed us in virtue of adjournment of the second case. We've indicated that the week of the 11th of November there will be no sitting, but beyond that, between then, that's from the week of the 18th of November to the week of the 9th of December, that is from the 18th of November to the 13th of December, we have 4 weeks that the chamber really feels we should fit in at least 2 more witnesses within that span of time. We're indicating a strong preference of the chamber. Again, we will listen to counsel on the matter, but this is the chamber's strong preference that within that period we should at least take in the testimonies of 2 additional witnesses beyond the 2 we are now looking at for this week.
I'm grateful, Mr. President, and will be guided accordingly. Your Honours, as we always say, we're entirely in the court's hands.
That is very good news, Mr. Khan.
Your Honours, would the court be amenable that we have discussions and maybe come back with a, not that we have any say in the matter really, but we can put forward a preference to the chamber, and if that preference is amenable to all parties, and of course the bench, then maybe that can be the period, the 2 weeks that we choose. From our point of view, we'd rather have 2 consecutive weeks rather than dividing them, indeed.
That would be a good suggestion. Would you also try and liaise with the prosecution? It's always better if counsel liaise and come up with a common position. That makes it easier for us to make a decision or give a direction on the matter.
Indeed, Mr. President, I'll speak to my learned friend, Mr. Steinberg, at the break. The other matter that would be useful, because it does have actually a lot of financial implications. My learned friend, Mr. Fowler, has just lost almost £900 sterling because of the change of tickets. So it's expensive for the defence. I know my learned friend had a preference for the prosecution to come back the second week of January because of various matters that he detailed. Again, it would be useful whenever the court is able to consider that matter to get a date so we can plan our own obligations accordingly. But Your Honours will.
But that's a different consideration.
Indeed.
Good.
Indeed.
We are talking about fitting in at least 2 more witnesses before the winter
before the 9th
recess,
of December.
yes.
Indeed, agreed.
Yes, Your Honour, we'll discuss it over the lunch break. From the prosecution side, it won't be a problem.
Good. Mr. Kikin-Katwa, I take it the same. So all lawyers will discuss the matter and then we'll take it up again later.
Yes, Mr. President.
Yes. And then you have your own matter.
Yes, Mr. President.
Do you want us, we're in open session? Is this something that's appropriate to discuss in the open session, or should we go into private session?
It's okay to raise it in the open session, Mr. President.
Then proceed.
Your Honor, as is obvious, our case depends mainly on what was broadcasted, which we have reduced into transcriptions and translation. The court will recall that this witness testimony in relation to my client was mainly voice recognition of a an audio. We have prepared our defense around the same subject of his recognition of the voice and the possibility that he had those broadcasts. And our main interest with him would be, from time to time, recognition of the voices of the people who are at the station. And I have indicated to my learned friend, Mr. Garcia, that if it is agreeable, I could have the witness identify the voice and then subsequently read out the other parts of the transcript, as opposed to playing the audio for each of those timestamps that I need to make reference to. That way we will cut down on time, Mr. President. That was the point I wanted to raise, and that would really cut down on time.
So you just want him to recognize, to indicate whether he recognized the voice, and
Mr. President, what I would do is that in respect to the audio I wish to make reference to, I would play the first timestamp that I might want to make reference to. And using that timestamp, extract from him voice recognition and the subject. But subsequent to that, on the same audio, I don't need again to keep playing the audio. Yes,
so then you use the transcript.
Yes, Mr.
All right. Mr. Garcia, do you have difficulty with that proposal?
Your Honors, our problem is, and I understood this from a conversation I had with Mr. KenyaMOJA during the break, is that some of the audio has not been fully translated. I understand that's the case maybe with 2 of the audio recordings, and if that is the case, then obviously I don't think we should be using those in court with the witness, since none of us will be able to follow what exactly is being said, except for the people who can understand the language in the audio recordings. That's the first thing. As for the audio recordings themselves, the prosecution is going to object that they even be, that the witness may even be made to listen to these audio recordings. In our opinion, it's just simply self-serving evidence. Now, the fact, I understand there are several, I haven't counted them, but there's a certain number of these audio recordings. Some of them are quite lengthy. The fact that the witness, or that Mr. Sang indeed at some point in time would have made, and actually most of them date from the Christmas season, Your Honor, the holiday season, would have made comments promoting peace to the people or to the listeners. It doesn't negate in any way the fact of what the prosecution is maintaining, the fact that he did make inciting comments during his broadcasts at certain time periods. So this is the main problem the prosecution has. In light of the limited amount of time that we do have, I don't see what is the relevance and the probative value of these audio recordings. It's just the witness, or actually in some cases it's not even Mr. Sang, it's Bishop, and I can refer to them, it's a bishop as well making statements during the holiday season, and this is completely irrelevant for the case. It's not the bishop who's accused, but Mr. Sang. So on that basis, Your Honor, I don't see the purpose of why we would be wasting the court's time and resources on these audio recordings. Mr. KenyaMOJA can clearly do this in defense. He can have Mr. Sang himself identify these recordings if it is probative of anything in this case. But I submit...
Didn't this witness testify to having heard Mr. Sang make certain broadcasts, and wasn't that part of the evidence of the witness?
Yes, the witness did claim that infrequently he would listen to Cass FM.
Right.
He can identify the voice if that's the extent of it. But what I'm stating is that for the rest of it, the content, the witness is not going to be able to authenticate it, obviously, for the court. And it's all primarily self-serving evidence. So if it's simply for identifying the voice, well, then that's one matter. If it's to admit that into evidence, well, the prosecution is going to say that it should be admitted, but simply for identification purposes. Another concern that the prosecution has is, and I understand Mr. KenyaMOJA has told me that he will have the originals, but do we have the originals of these tapes? I understand that during the opening statement, Mr. KenyaMOJA stated that they did have a stock of Cass FM recordings. We've made requests for these recordings in the past. What we'd like to ensure ourselves is that if indeed there are recordings that are going to be played to the witness, that Mr. KenyaMOJA provide the full recordings, not just extracts, and that they be the originals, so we can obviously submit them to some sort of expertise to determine whether they are authentic or not. So those are the concerns of the prosecution in regards to the recordings.
Mr. Garcia, I've heard you say this, use this argument a number of times in the past, indicating objection or concern that the defense tendering self-serving evidence, unquote. Is there any authority for the proposition that an accused person who's making a full answer and defense may not tender self-serving evidence? Isn't that the whole point of a defense?
Your Honor, what I'm merely pointing out in this case is that the recordings are self-serving in the sense that they don't provide anything which is of relevance in the case at this point. The simple fact that Mr. Sang would have made a recording on the 25th of December promoting peace, it's actually irrelevant to the case at this point, because the witness, what the prosecution is suggesting, and the evidence demonstrates it, is that he would have made inciting comments. That's
so your
the
point
of
then, your argument is not self-serving as such. That's not the objective. Your argument is that it is not relevant.
Your Honor, exactly. It is irrelevant at this point. There is a notion, obviously, of self-serving evidence, which is a very limited scope, where an accused would say that he's not responsible or he hasn't committed an offense. That's not the case. In that case, you wouldn't be able to lead it through the prosecution's evidence. But it is self-serving in the sense that it's just consistent with what the defense has been maintaining from the start of their opening statement, that the accused never made any insightful comments.
No, let's not confuse things. When you say self-serving on the part of an accused person who's giving, that's a different question as to whether or not the trier of fact should give that sort of statement any value against the background of the charge. That's a wholly different question from whether or not the evidence is admissible to begin with. Those are two different considerations. So your argument has to be that the testimony is irrelevant, in which case then we will make a determination, the chamber will make a determination as to whether the evidence is relevant or irrelevant, and make a ruling at that point, but not because it is self-serving. That cannot be a basis to inadmissibility of evidence for the defense.
I understand, Your Honor, and basically that is my argument, that it is irrelevant.
Fair enough. Mr. Keegan-Katwa, the prosecution's concern is that the part that you indicate you may not play in order to save the court's time may have issues of authenticity about them. That's what I understand the argument to be.
Your Honor, I understood it a little bit differently. I understood his concern to be that I proposed to play some audios which do not have translations, and whose consequence is that it is only understandable to a select people.
All right, let's do this. Let's do this. Let's go into private session.